Hi, I'm Jim Stroud, and this is my podcast. Don't let employee lawsuits kill your company. That's the advice of Matthew Grabell, the author of The Employee Lawyer's Playbook. We had a very good conversation. Actually, I think it was a little short. Hopefully, I can have him come back one day. But when I say an interesting conversation, here's a snippet of what I mean.
People aren't verbalizing their desires or their discriminatory, animus towards others. They're actually putting it in text and social media sites. So you'll see, and I saw plenty of cases where a supervisor would, send a sexually harassing text or email or other social media posts to a female employee or a male employee for that matter. And that's what I mean by that. Those kind of errors, everything is in writing these days. And believe it or not, Jim, excuse me, courts around this country and judges, if you are accused of discriminatory, harassing behavior or retaliatory behavior, and there's evidence that you use texting or social media, they will order the other side, the employee lawyer like myself, the ability to get your texts and social media postings and emails and Facebooks for the past year or two. Now, I don't think anybody wants that.
What? Really?
Yeah.
Even if it's, so it wouldn't just be social media that was created during work hours, so to speak, or anything in my personal social media they could pull.
No, everything.
If you want to protect your company from employee lawsuits, you must listen to this episode that will begin right after this. The Recruiting Life is a newsletter that gives a quirky view on the world of work and aspires to educate, entertain, and inspire with articles, comics, podcasts, videos, and more. It is produced on a weekly basis by yours truly, Jim Stroud, and is supported by readers like you. Topics in this newsletter include the future of work, current labor trends, the impact of AI on the recruitment industry, and more. Subscribe now and receive it every Monday in your email by going to jimstroud.beehiiv.com. That URL is jimstroud.beehiiv.com. A link is in the podcast description. Don't wait. Subscribe now. Operators are standing by. Hello, and welcome to another exciting episode of the Jim Stroud podcast. Today, we have a very special guest. Tell us, who are you? And what do you do?
My name is Matthew Grabell. I've been an employment lawyer for over 27 years, and I do employment law training in a live format to corporations around the country. And I recently wrote a book called The Employee Lawyer's Playbook, the top 10 mistakes that employers make that plaintiff lawyers will seek to exploit. And I include in that book real case examples and of each of the errors that employers make.
Is that available on Amazon?
It is available on Amazon. Good question. It was actually a bestseller on Amazon in the first week. I was thrilled and excited. So
very
nice. We're doing well.
Very nice. What inspired you to write it?
Well, that's a good question. A lot of things inspired me to write this book. Employee lawyers have what's called a playbook of a plan of attack, so to speak. Where they want to attack the company, the managers, other employees, statements, documents, and so forth in order to increase the value of the settlement or the verdict at trial. How do I know this? Because like I said, I was an employee lawyer for over 27 years, suing companies. So now I try to turn the table. I've kind of switched teams because I saw so many managers and executives make stupid mistakes. Various mistakes over and over again. And I said to myself, the training that these companies are providing is obviously not doing the trick. So I thought it would be a good idea to switch teams and give the perspective of training from the employee lawyer that used to sue them. And that's what I have done. So I've incorporated that strategy into my live training sessions. And I now have a book to also use as a takeaway to any client that hires me to do training.
Can you briefly explain the top 10 mistakes employers make that plaintiff attorneys seek to exploit?
Sure, it's detailed, obviously more detailed in the book, but the top 10, in no specific order, is unfamiliarity with policies and procedures or the law. And that sounds simple, but a lot of managers are not familiar with the policies that an employee will come to me and say, hey, they violated this policy and I want to know why. And, you know, to start off, before we even get into this or continue with this, you have to know that employers can take any action against an at-will employee that they want to, except they can't take action for a discriminatory reason, such as based upon age, sex, race, religion, disability, marital status, pregnancy. Those are protected characteristics. So to go back to my first example, unfamiliarity with policies and procedures, there are a lot of people that would come to me and say, you know, hey, my manager violated this policy by not doing, you know, progressive discipline, for example, and I don't know why. And then if I got into questioning, I would find out that they recently had an accommodation request for a disability, or they were the only African American in their group, or they just had a 65th birthday, something that triggered one of those protected characteristics, or they just became pregnant, something like that. So that would make an employee lawyer like me ask a lot of questions if a company was unfamiliar with the policies, procedures of the law. The next one that I cover is erroneous or non-existent documentation of personnel decisions. Again, that sounds simple, but you can't imagine how many times I have gone through performance reviews or other documents in a file, and there are inconsistent statements in there, or there are missing documents altogether. There's no performance review or disciplinary review. And what I like to say, if the employment decision is not in writing, it didn't happen. So I'd like to train my companies on that when I tell them, be honest and put it in writing so that you have a record. The next one would be performance review puffery. And you may say, what does that mean? Well, there are plenty of managers that when they fill out a performance review, they put in only positives, and they may even enhance those positives, and for various reasons. But then sure enough, a month, 3 months, 6 months later, they fire that individual, and the excuse that they give is poor performance, even though they're hiding a discriminatory reason. Right. So when I go through that performance review and I say to the manager at his deposition, why did you rate this person so highly? I'll get different excuses. Well, I wanted them to get their year-end bonus, but I was just trying to be nice. You know, verbally, I told them that they needed to improve and so forth. That's a big error, big mistake. The next one will be an inadequate response to an initial complaint. And by that, I mean that when an employee does come to human resources or to any manager or supervisor with a complaint about discrimination or harassment, you have to take it seriously and you have to respond. The legal term is, you know, in a prompt and effective manner in order to, you know, remediate the issue. So that's what's litigated, whether it's prompt and effective. So could it be prompt and effective if it's done within that same day or 24-hour period? Sure, that would be prompt. But, you know, a lot of companies will say, or managers will say, you know, oh, you know, Jim touched you in that way, or Joe touched you in that way. He does that to everybody. He hugs everybody, or he touches it. Get back to work. Or, you know, I'm not your babysitter. You know, we have a project that's due. And they don't address the complaint in a prompt and effective manner. And that's a huge error. Inconsistent statements in response to a claim is another one. And by that, I mean, a lot of times an employee will file a claim either with the Human Resource Department or outside with an agency such as the Equal Employment Opportunity Commission. And normally in those situations, the company does not hire an attorney to handle that because the employee can go there for free without an attorney. And they normally will have a manager or human resource person answer the questions and deny that there's been any discrimination going on. Go ahead.
No. I was just going to interject there for a quick second. as you were saying these different things, I was thinking to myself that it's very expensive when a disgruntled employee files a complaint against an employer. What makes it so expensive? Is it just a legal fee cost? Or I'm just
Well,
curious
that's a
if you
good
jumped in on
question.
it there. Yeah.
For an employee to go to an agency, whether it's a state agency or the EEOC federal agency, there's no charge to the employee. But
Okay.
if the company wants to use their attorney, their in-house attorney or outside counsel, then it will start to obviously run up a bill. So my point in this error, in pointing out this error, is a lot of times with the agency response, the company will not hire somebody and the human resource person will answer the questions. And that creates a document path that later, if there's not a resolution, the employee then gets the option to file a lawsuit. And a lot of times that's when I will get called in. And I will look at the documents that were submitted to the EEOC, for example, and I might ask similar questions during discovery of the case, which is now maybe a year or two later, believe it or not. And I will see totally different statements made, inconsistent statements made that were made to the EEOC versus what's made to me in terms of reasons for termination or disciplinary issues, but things like that. And those kind of inconsistent statements raise a red flag every time to a judge or a jury. It looks like the company's making something up, right? It looks like they're just faking it. So to go back to your question though, Jim, which is a good one, it does get expensive for a company because if you think about it, when they have to hire a firm to represent them, the firm normally takes a retainer. They don't work on a contingency like an employee lawyer does. Yep. So they take the retainer, that could be several $1,000s, and it's against hours that are put in. As soon as those hours are used up, they ask for another retainer and another retainer. This could be $10, $20, $30, $40,000. And then they have to go through the discovery process and motions and court dates and talking to witnesses and securing statements. It can be very expensive. And this is what companies many, many times will underestimate the value, not just of the money part of it, but the time loss and the morale to the whole company, right? They have to stop what they're doing. They're not productive anymore. Now they're responding to Jim Stroud's, complaint that they think is BS, but they have to respond to it and answer all these questions and court dates and so forth. So it becomes very, very expensive, not just money, but morale.
Yeah, so, I see it. So it's really the expression, an ounce of prevention is worth a pound of cure. Is really to a company's benefit to sort of squash these things to everyone's satisfaction quickly and early.
Which is why I like to say that my training, coming from the perspective of the employee's attorney, should help do that. Because if people follow my steps that I go through in the training and in this book, when an attorney like me takes the case and they start seeing the documents and the support for the company's position as the months go on, they're going to drop the case because they're going to see, hey, we don't have a winning case here anymore. This company did everything properly. And that's the position I want to put companies in with my training and this book.
Now, you've been practicing employment law for 27 years, give or take. Have you seen the landscape of employee lawsuits evolve over time? The things that happened maybe early in your career don't happen so much now, or maybe more so now?
Yeah, I have. That's a good question too. When I first started this years ago and I started getting into employment law, I used to talk to my adversaries, the defense attorneys, whether it was at a deposition or after, motions were made. And you would be able to talk to the person and say, look, this is positives on my side. These are positives on your side. I have to deal with this negative. You have to deal with that negative. Let's try to talk this through, shake hands, and figure out a way to make everybody happy before this gets out of hand. Very rarely do you see that anymore today. It's a very much adversarial process. I'm not proud of that, but my goal, again, in trying to bring a different perspective to companies through the training and through this book, is to minimize that adversarial process and hopefully get people back to where they're talking things through and resolving it early before it's too costly and time consuming.
is the you mentioned in your book the fear of employee lawsuits among executives. Everybody's afraid of lawsuits. What's driving that fear? Is it just the economical impact, or is it morale? I mean, what do we think? Why are most executives afraid of a lawsuit
Well,
from
many
employees?
times,
Yeah.
many executives and companies are afraid of this because for a couple of reasons. Number one, many states now have individual liability. So it used to be that an employee would sue you heard the term deep pockets. They would sue the deep pockets, which is the company.
Yeah.
Now, many statutes in various states allow the employee to sue the individual as well. So instead of just suing a company, I can sue the manager who caused me my grief. And
Really?
that you can imagine with your raised eyebrows, Jim, that that will cause plenty of fear among
Yeah.
somebody.
I was thinking that employees only sue the company. So, wow, I didn't know
Nope.
you can get down to the actual manager.
You can get individual liability, and the worst part about that is if there is enough evidence of the individual taking action on their own, discriminatory or retaliatory action on their own, the company will distance themselves from that individual. In other words, they might not pay for their defense. So now that
Mm,
individual has to get their own attorney, pay their own retainer that I talked about before, which could be tens of thousands of dollars. And that is where it gets expensive.
wow. Wow.
Yeah. Yeah.
Now, is that something that can because that can impact someone's career, I imagine, because if you are doing a background check on someone or you're calling for references, that kind of thing will come up. Yeah. If I call the company about, I don't know, Joe Schmo, HR manager, and I say, you know what, I've heard some interesting things about this manager. What can you tell me about him? The company is going to just basically give name, rank, and serial number, right? And are they obliged to say this person was involved in a lawsuit?
They're definitely not obliged to do that. In every case that I have ever had that had a settlement, part of the settlement agreement is that for the employee, at least, they will only give dates of employment and last position held. For a supervisor or manager that was on the wrong end of a lawsuit that was being sued, if the lawsuit was actually filed, that's a public document, Jim. So there's very little to
Ooh.
hide behind. Once the lawsuit's filed, that's a public document. You can go to the courthouse where you live
Mm-hmm.
and Google, not Google, but search the files for somebody's name to see if they have any lawsuits against them. And you might see some, car accidents, but you might see an employee lawsuit, and then you
Wow.
might not want to hire them.
Does the average background check involve that as far as looking
Yeah,
court?
it will.
Okay. Okay.
It will have the average background check will show criminal records and court records and documents, depending on how in depth a new company wants to go in terms of the reference.
Mm, that is that okay. I can see why that's can be very scary.
Yeah.
um, Something else you mentioned in your book too, quick trigger termination. What is that, and why is it a common error for supervisors?
Yeah, that's one of the other errors I didn't get to yet because we talked about some other very good questions that you brought up. But a quick trigger termination means many times a supervisor, if they're holding some type of discriminatory animus towards somebody, they
Mm,
want to fire that person, right? Maybe they weren't involved in the hiring process, or maybe they were, but something came up like pregnancy or a religious accommodation or disability or something of that nature, and they want to get rid of this person. So they might, as soon as that person is 5 minutes late, they might quickly pull the trigger and fire that person. You came in late.
mm.
This is your third time coming in late, as opposed to checking with human resources first. That's what I mean by quick trigger. They make the firing decision right away without checking with human resources. And if they had checked with human resources, they might find that maybe this person had an accommodation to come in a little bit late because they have a disability that makes them, delayed in the mornings, or maybe they're pregnant and they have to see their doctors, whatever the reason is. The quick trigger termination just means a supervisor acts too quickly without discussing it with others in the company to make sure that he's on safe grounds to do so.
Even if it's an at will state.
Even if it's an at-will state, because let's say the person has the disability, or let's say the
Mm.
person made a complaint about the supervisor a week ago, and the company was ready to, going to do an investigation, but the supervisor then fires the employee. Now that could be seen as retaliation for that person making the
Oh,
complaint,
yeah,
right? And the
yeah.
complaint could have been age, sex, race, religion, or disability. I'm not talking, Jim, about complaints, that somebody stole my pencil. I'm talking about complaints, of discriminatory or harassing conduct where the company has an obligation, a legal obligation to do an investigation, and the supervisor takes it upon him or herself to pull the trigger on that termination before checking with the rest of the company.
So one of the other areas of your top 10 that I didn't get to let you get to, which I probably should have, was on texting and social media errors, right? So talk to me a little bit about that. How can employers navigate electronic communication to avoid legal pitfalls around texting and social media? Because those social media errors, I'm thinking nowadays, like I heard this one podcast, Tim Pool, right? And he was talking about how some people were fired because they were pro Hamas, I think it was, and they were being belligerent in the workplace, and they were posting things about their coworkers on social media. Big mess, big mess, big mess. So how can companies sort of get around that? Because it's going to be something political tomorrow. It always will be. What can you counsel employers on that?
Well, there's two aspects of this. Number one is from the supervisor's perspective, using texting and social media. And what I like to say when in my training is that when I started in this business, we used to use the term "he said, she said." I'm sure you've heard
Mm-hmm.
of that, Jim, and
Yeah.
your audience members.
Mm-hmm.
And that simply meant that, one person said one thing, another person said another, and it's a toss up as to who you believe. Well, nowadays with texting and social media, people aren't verbalizing their desires or their discriminatory, animus towards others. They're actually putting it in text and social media sites. So you'll see, and I saw plenty of cases where a supervisor would, send a sexually harassing text or email or other social media posts to a female employee or a male employee for that matter. And that's what I mean by that. Those kind of errors, everything is in writing these days.
Mm.
And believe it or not, Jim, excuse me, courts around this country and judges, if you are accused of discriminatory, harassing behavior or retaliatory behavior, and there's evidence that you use texting or social media, they will order the other side, the employee lawyer like myself, the ability to get your texts and social media postings and emails and Facebooks for the past year or two. Now, I
What?
don't think anybody wants that.
What?
Yeah,
Really?
yeah.
Even if it's so, it wouldn't just be social media that was created during work hours, so to speak, or
Oh,
anything in
no,
my personal social media they could pull.
no, everything. If you're accused of something heinous, like discrimination
Yeah.
or sexual harassment, a judge may order your phone to be turned over and your text messages and all your emails from your home computer server,
Wow.
right, to find out, because you may have been sending these messages from home,
Wow.
and that's the allegation. And to answer your other side about how can they protect about like political postings and
Mm-hmm.
things like that, there are no protections for an employee when they post something on their own social media site and the employer finds out about it. So for example, you use the example of being pro Hamas
Mm-hmm.
or any political thing, pro Trump. If
Mm-hmm.
somebody posts something on a website and the employer finds out about it and doesn't think it it is in agreement with the company's philosophy or the message that the company wants to put out, you can be terminated. You can be terminated for that. Most people are turned in, by the way, by their quote unquote friends on Facebook, right? Because I might see what Jim posts at night and I go and tell, tattletale on you, hey, did you see what Jim posted last night? And that's how you get in trouble. The only protection for the employee is under the National Labor Relations Board, where if it's protected and concerted activity. So if you have a post that is protected, meaning it has to do with bettering the terms and conditions of employment, and it's concerted, meaning in concert with other employees, that's protected. So if I were to write on my social media one night, uh, you know, uh, we haven't gotten a raise in 5 years. I think we should get together and talk to the owner of the company about getting a raise. That's protected, right? Because it's protected concerted activity. You're talking about bettering the terms and conditions of employment. But if I just go on and I write something political or anything, it could be any statement at all. If it's not to better the terms and conditions of employment for you and other employees, it's not protected and you can be terminated.
That is interesting. So let me sort of, wow. So if I were writing about, let's say I worked at Starbucks and I say we need to start a union, and other people say, yeah, we should start a union, then that's okay, even though that might be a little tension at the workplace, but it's still protected. But if I were to say, this year I'm going to vote for Biden, or this year I'm going to vote for Trump, and the management is on the other side of the political aisle, and they decide to fire me because of what I posted, I can't do anything about it if I'm in an at-will state, I'd imagine. And there's no recourse for me.
Well, when you talk about political views, that brings in something else, because you have First Amendment rights to free speech, but that's only for the government to be protected. So if you're talking about Starbucks and it's a private employer, you have no protection. The First Amendment doesn't apply to private employers. People think that does. I have a First Amendment right. I can say whatever I want. That's not true. If the owner of your company disagrees with anything that you say or anything that you post or any sign that you put up, you can be terminated.
And I can't do anything about it.
You can't do anything about it.
And that's only, but is that only in at-will states or anywhere?
Yeah, anywhere. You have to be careful. That's the one. What your reaction is very typical to every reaction I do in trainings when I bring up the topic of the social media sites. People do not understand that, and I have to give example over example of people that were terminated for putting up, what they thought were just innocuous statements on their social media. But if the company finds out about it, doesn't agree with what you're writing, you could be terminated.
What if you are posting things on Instagram and your account is private? So you're assuming that you're only sharing it with friends and family, but one of your friends and family narcs on you to your employer, and the person could lose their job. Would they have a legal recourse then, or?
No. One of the examples I use in my training goes to that typical situation. And what you need to understand, what everybody listening needs to understand, when you put something on the internet, you should have zero expectation of privacy. Zero. One of the examples I used was at a restaurant, Houston's, which is Hillstone in some states and Houston's in other states. And the employees started a social media account for only employees to have access to. And they gave passwords to only the employees. And it was like a forum that employees could gripe about work or say whatever they wanted. So sure enough, what do you think happened? One of the supervisors forced one of the employees to give up the password. And when the supervisor went in and looked at what was being written, they actually found threats of violence and sexual harassment type of notes, and fired the people that started the account. And these people sued. And they said, I want my job back. And they said to the judge, we had password protected. This supervisor was never even supposed to see it. It was for employees only. And the judge said, doesn't matter if there's one password or 1,000 passwords. There's no expectation of privacy when you put something out on the internet. And your audience should know that, Jim.
Wow. That is very sobering.
Yeah.
Time is creeping up on us. If you would, leave us with this. In the world of employment law, what trends or changes do you foresee in the near future the HR leader should be prepared for? What's coming around the bend that we should be looking out for?
Well, look, everybody's talking about artificial intelligence, right? AI.
Sure.
And that has, that has not stopped at the walls and doors of employment law. It still gets into the world of employment law, and you got to be careful of that. That use of it will increase in the future. But what I will say, and the reason we still need to be vigilant and conduct training on not only social media and AI, There are still people like Archie Bunker out there, right? You remember All in the
Yeah.
Family?
Oh yeah. Oh yeah.
Okay, so Archie Bunkers do exist. I thought that those types of people went away a long time ago. But I found in my career these, racist, ageist, and just bad people that have these certain, feelings towards other people. It will not go away, whether it's age, sex, race, religion, disability, and so
Sure.
forth. And we got
Sure.
to watch out for that in the future. And that's why another reason why, to answer your very first question, why I put this book out and why I'm trying to promote training from the employee lawyer's side.
Okay. Very good. Very good. Um, we could go on and on, which I have no doubt. But if someone wanted to get more information from you specifically and to buy your book, how can they find you online?
Well, I am online. I have a website, employeerelationssolutions.com, and anybody could email me. I answer every email. mgrabell@employeerelationssolutions.com. And the spelling of my name is M for Matthew, Grabell, Grab like boy, ELL. And I'm happy to always answer emails and discuss with anybody.
And to make it easier for your audience, I'm going to leave a link in the podcast description. So look at the podcast description and you'll see information there, how you can get more, how you can contact him. Thank you so much for your time. This has been sobering on a lot of fronts. Thank you so much for your time. I appreciate you being on the Jim Stroud podcast.
Jim, thanks for having me. You're doing a great job. Enjoy it.
Well, my time is up. I thank you for yours. I'll see you again real soon right here with a brand new episode of the Jim Stroud podcast. If you have any questions, comments, or concerns, feel free to reach out to me. I can be reached by email at jimstroud@jimstroud.com. And one last favor, if I may ask, please rate this podcast. 5 stars is preferred, but please comment with your honest opinion. I really appreciate that. All right. Okay, until next time, bye-bye.